Welcome to the DX Today podcast, your daily deep dive into the AI ecosystem. I'm Chris, and joining me as always is Laura.
Thanks, Chris. And I have been waiting all week for this one because today we get to watch an entire generation of AI laws walk into a courtroom and find out whether they actually work.
Set the table for me, because I think most people assume that if there is one thing lawmakers have actually managed to regulate about artificial intelligence, it is fake political videos.
That assumption is correct, and that is what makes this so interesting. Election deepfake laws are now on the books in 31 states, according to tracking by the watchdog group Public Citizen. And if you widen the lens beyond elections to synthetic media generally, the count climbs to roughly 46 states as of this spring, which makes this the most heavily legislated corner of the entire AI economy.
Meanwhile, correct me if I'm wrong, the United States Congress has passed absolutely nothing on deceptive election deepfakes, which means the states are carrying this entire policy question on their own backs.
Congress has passed nothing on election deepfakes specifically, and that vacuum is exactly why the states moved. The whole wave traces to late 2022, when ChatGPT reached the public and synthetic media stopped being a research demo.
Right, because before that moment, you needed real skill and real compute to fake a convincing video of a politician, and afterward you needed a browser tab and about 4 minutes of patience.
Then in January of 2024, the nightmare scenario actually happened. Voters in New Hampshire received a robocall in what sounded exactly like then President Joe Biden telling them to sit out the primary.
That is the case everybody points to, and I remember genuine panic in both parties. What I do not think most people know is how the enforcement side of that story actually ended up resolving.
This is the part that should make every state legislator nervous. The Federal Communications Commission hit the operation with a $6 million fine, but Steve Kramer, the political consultant behind the deception, was acquitted of all criminal charges. So, the most notorious election deepfake in American history produced a fine and zero criminal accountability.
Okay, so that is the backdrop heading into this year. Walk me through what is actually happening on the ground in the 2026 midterms, because I gather it is genuinely messy.
Messy in a way nobody drafting these bills anticipated. Michigan Representative Penelope Cernoglu, a Democrat who passed a pair of election deepfake laws back in 2023, says we are going to see these laws tested and stretched to their limits this year. That is the author telling you the stress test is underway.
So what does that stretching look like in practice? Give me the specific incidents, because the abstract policy debate gets a lot clearer when you actually look at the advertisements themselves.
Start in Michigan, which is producing case studies faster than anyone can litigate them. Last month, the state Senate Minority Leader, Eric Nesbitt, a Republican then running for governor, posted an AI video to Facebook.
What was in it, and more importantly, was it labeled? My understanding is that labeling is the entire hinge on which most of these 31 state laws actually turn.
It was labeled, and that is the twist. The video depicted Democratic Governor Gretchen Whitmer about to be run over by a tractor, and because it carried an AI disclosure, it was arguably fully compliant. The Nesbitt campaign called the whole thing parody.
And parody is the magic word here, isn't it? I would bet money that most of these state laws carve out satire in order to survive the obvious constitutional objection waiting for them.
You would win that bet. Michigan's labeling law has a satire and parody exemption, and so does Oregon's disclosure law from 2024. Those carve-outs are load-bearing, and they are being tested directly.
Tell me about Oregon, because a satire exemption sounds perfectly reasonable in a committee hearing and sounds like an enormous loophole once campaign operatives actually get their hands on it.
Oregon's Secretary of State, Tobias Reed, is investigating a former Republican congressional candidate named Jonathan Lockwood over unlabeled synthetic videos depicting Representative Janelle Bynum, a Democrat. Lockwood called it a frivolous censorship complaint designed to weaponize what he described as Oregon's unconstitutional synthetic media law.
That framing is going to travel, because once you can characterize a labeling requirement as government censorship of political speech, you have moved the argument onto the most favorable terrain in American constitutional law.
And here is the case that best captures why the labeling theory may be fundamentally mismatched to the problem. In Kentucky's May primary, a conservative political action committee ran a fully compliant advertisement.
Fully compliant meaning it carried the disclosure, it said it was AI generated, it checked every box the statute asked for, and it still did exactly what everyone feared deepfakes would do.
The ad used AI to depict Republican Representative Thomas Massey in a romantic throuple with Democratic Representatives Alexandria Ocasio-Cortez and Ilhan Omar. It carried a disclaimer stating it was satire created with AI.
That is an extraordinary thing to put on the air with a compliance label attached. And I have to assume it moved numbers, or we would not be discussing it right now.
Massey lost that primary to Ed Galbraith, and afterward, he said on national television that the ad contributed to his defeat. His exact words were that it was actually very effective on the boomers, and the return fire was not compliant at all because a pro-Massey committee ran an unlabeled AI ad showing Galbraith, a former Navy SEAL, retreating from a battlefield while President Trump fought on.
Let me play devil's advocate for the laws, because I think the people who wrote them would say we are cherry-picking the strange cases and ignoring the disaster that never actually happened.
That is a fair pushback, and Public Citizen's own expert makes it. Alana Beller, who directs their state AI governance and tech policy work, says these laws really zero in on the harmful content.
And what does harmful mean in the statutory sense? I assume there is an actual legal test in there, rather than a general vibe, about whether an advertisement felt unfair to somebody.
The typical test targets content intended to harm a candidate's reputation or deceive voters, and realistic enough that a reasonable person would believe it authentic. Most laws require labeling within a set window before Election Day.
And presumably, they give the targeted candidate some way to stop the thing from running, because a lawsuit resolved 18 months after you lose an election is not much of a remedy.
Correct. Most give candidates the right to seek injunctive relief to pull an offending advertisement quickly. Minnesota and Texas go further and prohibit distribution outright within a window before the election. And Maryland bans election deepfakes year-round, according to the National Conference of State Legislatures.
Here's what I have been most curious about, though. Everyone seemed to converge on disclosure as the solution before anyone actually established that a label changes how voters process what they are seeing.
Scott Babwa Brennan, who directs New York University's Center on Technology Policy, has been tracking AI use in campaigns, and that is precisely his concern. He is not opposed to labeling, but he questions its effectiveness.
What is his actual objection? Is it that voters simply ignore the labels, or something deeper about the kind of harm that synthetic political content is really doing to the electorate?
His question is whether labeling requirements are up to the task of addressing the problems we are actually seeing. If the dominant use is satire depicting real politicians, a disclosure label may accomplish very little. He also raises an angle I had not considered, which is that using AI to depict a candidate may implicate name, image, and likeness protections rather than election law at all. That reframe matters because publicity rights are about control of your own likeness rather than deception. And content deemed commercial speech receives weaker First Amendment protection than core political speech.
All right, let's talk about the courtroom side, because not all of these 31 state laws are actually operative anymore. Where has the constitutional challenge already succeeded outright against one of them?
California is the biggest one. In a case called Coles versus Bonta, a federal judge struck down the state's marquee deepfake law, finding it discriminated based on content, viewpoint, and speaker while targeting protected speech.
Content, viewpoint, and speaker discrimination is essentially the constitutional trifecta of things you cannot do to political speech. That is not a narrow technical loss. That is a court rejecting the entire architecture.
It is, although California's separate labeling statute remains in effect, which tells you something useful about where the survivable line might be. Then, Hawaii lost its law in a case brought by a satire website.
A satire website suing over a deepfake law is almost too on the nose, but that is exactly the plaintiff you want if you are trying to break the parody carve-out wide open.
The Babylon Bee sued, and United States District Judge Shanlin Park granted them summary judgment, permanently blocking enforcement of Hawaii's Act 191 on both First and 14th Amendment grounds.
And what was the reasoning? I am curious how a judge articulates the problem with simply requiring a label on something that is admittedly and intentionally fake in the first place.
The reasoning included a line I find genuinely clarifying, which is that a mandatory disclaimer on parody or satire would kill the joke and impermissibly alter the message the speaker intended to convey.
So California partially struck, Hawaii fully struck, and I assume more challenges are queued up now that plaintiffs have watched this theory succeed twice in federal court within a single year.
Montana's law is currently being challenged by a political committee accused of sending unlabeled, digitally altered mailers in a pair of state legislative races. That pattern is going to repeat in a lot of places.
Here's my read on where all of this leaves us. And I think the pattern extends well beyond deepfakes. 31 states legislated fast against a vividly imagined harm, the fabricated video that steals an election. Then, the actual harm showed up wearing a compliance label and walked in through the front door.
That is precisely it. The Kentucky ad was legal. The Michigan tractor video was legal. What legislators feared most, outright deception, turned out less common than something they barely regulated at all, which is degradation.
And degradation is much harder to write a statute about, because the moment you prohibit demeaning synthetic depictions of politicians, you are regulating political caricature, which has roughly 2 centuries of protection behind it.
Which is why the courts keep siding with the satirists. 2 laws down, 1 under challenge, enforcement described by everyone involved as spotty, and the largest fine in the field paired with a criminal acquittal.
Say more about spotty, because listeners should understand the enforcement gap is not theoretical. What actually happens when a candidate believes they were targeted by a non-compliant synthetic advertisement this year?
Mostly they sue on their own dime. A Republican state Senate candidate in Michigan named Jason Tunney sought $150,000 in damages from an activist in May, and this month, an Arizona Republican congressional candidate sued a super political action committee over unlabeled billboards carrying unflattering AI-generated images of him.
Which is fairly damning for 31 statutes, because if enforcement depends entirely on the resources and appetite of the person targeted, the deterrent effect on a well-funded committee is close to zero.
And that is the lesson I would carry into every other AI policy fight, whether it is training data, chatbot disclosure, or algorithmic pricing. Passing the law is the easy part, and it does not determine the outcome.
One last thing before we wrap, because I want to give the optimistic case its due. Is there a version where these laws are quietly working and we simply cannot observe the deterrence?
There genuinely might be. Beller says most AI content this cycle has either been labeled or was clearly satirical, and mostly not anywhere near the nightmare scenario, which could mean the disclosure requirements are actually being followed.
Which feels like the right note to end on, because the honest answer is that we built a large regulatory apparatus on an intuition, and we are only now collecting the data to evaluate it.
31 states, 2 laws struck down, 1 under challenge, a $6 million fine with an acquittal attached, and a satire exemption that may be swallowing the entire framework. That is where we stand today.
That's all for today's episode of the DX Today podcast. Thanks for listening, and we'll see you next time.